All right, this is State of Ohio versus Julene Simko, 18CA011267. Each side will have 15 minutes in which to present your argument. Of course, appellant may reserve up to 5 minutes for rebuttal. If you wish to reserve rebuttal time, Ms. Bremke, just let me know when you begin your argument, and I'll try to monitor that for you. Please don't mention the name of any victims or witnesses to the best that you can help yourself in this matter. I know it was pretty complex in terms of length of trial. We have, well, we'll tell you, we are being visually and audibly recorded as well as being live streamed on YouTube as I speak. We have read your briefs. We are ready to begin when you are. Ms. Bremke.
Yes, Your Honors. Giovanna Bremke on behalf of Ms. Simko. If I could reserve 5 minutes of my time for rebuttal. As Judge Callahan noted, the facts are elaborate in this case, probably the most elaborate of any case that I've had before you, and you know I'm here a lot. But ultimately, Ms. Simko was charged and convicted of 6 counts, including aggravated murder and several other murder counts, felonious assault, and a tampering charge. This stems around a marriage. Mr. and Mrs. Simko were married, and Mr. Simko died in November of 2009. This case did not proceed to trial until 2017. Ms. Simko was not indicted until 2014, and just a few weeks ago, it was 11 years since Mr. Simko's passing. So there has been, the elaborate nature of it is that it has been a while. Ms. Simko was, the transcript indicates that she was sleeping on the 3rd floor of the home. Mr. Simko was on the 2nd story of the home. Ms. Simko heard a shot, believed that Mr. Simko was shooting coyotes out of the window. They lived in the country and were avid shooters. She goes to the 2nd floor of the home and realizes that Mr. Simko had been shot. She also calls 911 frantically. I encourage you to listen to that call. It's part of the evidence as Exhibit 13. She also fires off before she calls 911, fires off a warning shot with what was determined as a different weapon than the murder weapon. She indicates on the 911 call that somebody is in the home and that she is scared of the intruder and doesn't even go downstairs to let first responders in for that reason. She performs CPR, and upon entry into the home, one of the first responders was a sergeant who puts the revolver in the small of his back and without gloves and empties the chamber into a shoe. There's none of his DNA ever found on any of these items. There's a lot of talk about security systems, and again, I'm simplifying this because of the long nature of it, but there was different security systems, a driveway alarm, and also security cameras and a door alarm. There was holes in the system, meaning there was areas that the cameras didn't cover and the alarms didn't cover. There was talk about other suspects, Mr. Brandow, who would know about the holes in the security system and also have access to the home, know about the dogs that were also used as security, and had a violent history and a history with firearms. There was also footsteps in the snow, which led to I believe there was footsteps in the snow, and also a passerby had indicated that there was an individual walking down the street around the same time as this would have happened. There was 4 different interviews with Ms. Simko. All of those are in the record. 3 of them were a short period after the death, and then 1 was years later. The state tried to prove motive, and what the trial court concluded was that they, I think his quote was, didn't come close to proving a motive, but 2 of those motives were of financial difficulties, and then also that Mr. Simko was sexually assaulting Ms. Simko as she had been assaulted as a child. Again, that's elaborate in the record. Like I said, this took a while to get to trial. It was a bench trial, and it was a pretty lengthy bench trial. The first and second assignment of error deal with the court's verdict, and you're going to find that in the 9th volume of the transcripts. And the verdict itself is about 33 pages. And throughout that verdict, the trial court repeatedly states that essentially the court had concluded that there was 3 possibilities for the murder. 1, Ms. Simko. 2, he refers to as a robber stranger, somebody who broke into the home to rob it and was a stranger. The 3rd was an assassin. In establishing these 3 potential possibilities, the trial court said, altered the standard, basically altered the standard of proof beyond a reasonable doubt, and said that because the trial court did not find that a robber or an assassin committed these crimes, that Ms. Simko had to have done it by default. You're going to look repeatedly, transcript page 1456 and 1457, where the trial court talks about these, and I quoted some of these different areas in my brief as well. We know by the U.S. Constitution, the Ohio Constitution, and the revised code that the standard is proof beyond a reasonable doubt. That is one of them, if not the most important principle of our criminal justice system. And altering that standard leaves this court no choice other than to reverse the conviction. What we know is that the state has put in their brief that essentially there's a law that says in a bench trial, the court's presumed to know the law. And so I want to address that because the 9th District case that the state cites, it's Vimpney. Judge Schaefer was the author of that. And there's specifically a line in there that says, the record is silent as to this, so we're going to presume that the trial court, because they're a judge, knew the law. This is not silent at all. Like I said, it's an entire volume of the transcript almost. The trial court goes into great detail. In the courtroom, it was about 45 minutes to an hour of an explanation of how the trial court got to this conclusion. And so I think that what the law says is that the court is presumed to know the law, but we can't just dismiss the fact that we have an advantage, I guess, in a bench trial if the judge does make an explanation, because we know how that verdict was reached. We would never have that in a jury trial.
Counsel,
but yes.
Counsel, I'm sorry to interrupt you, but I'm just looking at the state's brief where they quoted the court saying, this court finds there was sufficient evidence to establish by proof beyond a reasonable doubt that Mrs. Simko was her husband's murderer. How do you get around that? I mean, that seems pretty clear cut.
So again, I think that one line that the state quotes comes after 33 pages of an analysis that is not proof beyond a reasonable doubt. So you can call it what you want, but it is very clear that this was not proof beyond a reasonable doubt. This was two mystery people did not do this. So Miss Simko must have done it. What we know is the state has to prove that Miss Simko did it beyond a reasonable doubt. And that's not what the court concluded. So they may have said that, but that's one line of 33 pages. And if you look at my brief and repeatedly where the standard is said, not just once like the state's brief, but repeatedly said, I find that because these two other people didn't do it, that Miss Simko must have, and that's not the standard. Along those same lines, my second assignment of error deals with the shifting of the burden. So the state or the judge, again, says that the state didn't come close to establishing a motive, and because of that, he's looking at these other individuals. And because it says that, this is transcript 1456, it's the defense's invitation to prove that somebody else did it. He shifts the burden to the defendant to prove that somebody else must have done this, so Ms. Simko did not. We know, again, that there's no shifting of the burden in this case, that the state has the burden, by proof beyond a reasonable doubt. And again, this is well established. Again, the court, again, puts a burden on the defense in transcript page 57, I'm sorry, and this is all in my brief, but the court says, I weighed both sides. And again, the defense doesn't have a burden. They can sit there and say nothing, and they don't have the burden to prove that these other people did not commit this crime. The focus should have been on Ms. Simko and whether she committed these beyond a reasonable doubt, and there wasn't any evidence to that effect that the court found in its 33-page verdict. The court spent a lot of time analyzing analyzing whether these other people did these crimes, and as a result of that, shifted the burden and concluded that the defense basically failed to meet their burden that they didn't have. Again, this is a clear error. The third and fourth assignments of error deal with sufficiency and manifest weight. Again, the facts are very elaborate in this case, but the sufficiency, again, deals with the court's verdict, and I again encourage you to review that entire 33-page verdict, volume 9, the entire volume. Even in sentencing, there was a correction of some of the things that were talked about, such as the driveway alarms, and that were incorrectly analyzed. And there's discussion about these mystery people, and in looking at those mystery people, again, no proof, insufficient evidence to show that Ms. Simko committed aggravated murder.
Just so you know, you are into your rebuttal time.
Okay, great. I'll finish just with the manifest weight. Again, I want to draw your attention to the DNA not being on the gun, and there's some other situations where there was a recorder that was left recording, and this is transcript page 190, and the detective from the very beginning said, I think that Julene did this, and the error in the driveway alarm that was corrected in sentencing on page 1506. So I will reserve the rest of my time.
Mr. Murphy. Yeah.
Thank you, Judge. Good morning. Brian Murphy, Assistant Prosecuting Attorney, Lorain County Prosecutor's Office, representing the state of Ohio. Julene Simko is before this court appealing an aggravated murder conviction, and she's appealing it based on what ifs, conjecture, speculation, and innuendo. The state's facts as presented during trial, the evidence presented during trial, established beyond a reasonable doubt, without any burden being placed on the defendant, that she shot and killed her husband of 10 years, Jeremy Simko, in their home as he slept, likely just before 6 a.m. on November 18th, 2009. The evidence compels that conclusion that Julene Simko ended Jeremy's life with a single gunshot wound to the head. Now, I'm going to go to the third assignment of error, the sufficiency argument, and let's talk about the evidence that the state presented. The one thing I'd note is whatever the judge said, first of all, doesn't go to the sufficiency of the evidence. He was able to determine credibility in his, as Ms. Simko describes, 33-page opinion. None of that is relevant as far as the sufficiency of the evidence goes, which this court reviews de novo. So let's look at the evidence, and frankly, the elements of the offense generally or predominantly are not at issue. What's at issue is the identity of the person who purposely, with prior calculation and design, caused Jeremy's death. And who is the shooter? Who is the killer? Well, viewing the evidence again in a light most favorable to the state, any rational trier of fact could have found that Julene Simko shot and killed Jeremy. Admittedly, the evidence is basically circumstantial, but that makes it no less probative than if someone had actually watched Julene shoot Jeremy. But we start out with the time. It's 6 a.m. That's an unusual time to carry out a stealth home invasion, particularly knowing that if there were some intruder, that intruder came without the firearm that was used to kill Jeremy. And how do we know that? Because we have this .357 Magnum revolver that belonged to the Simkos, that was in a china cabinet, because we have an empty holster in the china cabinet, and no indication that that gun should have been on the ground, other than if some intruder came into the house without a weapon. That makes absolutely no sense. The gun gets left on the kitchen floor, purportedly, under Julene's theory, as an intruder's running out of a house after having been shot at multiple times. That makes no sense. We know it had been removed from the china cabinet, and we know that it's the murder weapon circumstantially, almost certainly, because we have the projectile jacket fragment on the floor in the bedroom where Jeremy was killed. It has Jeremy's DNA on it. And the firearm expert determined that it had general characteristics of being fired from a .357 Smith & Wesson, based on the 5 right-hand twists in the land grooves. And the cylinder position is to the right. So it had turned as if it had just been, a single shot had been fired. So the open position is right after having been shot in this revolver. If there's an unknown intruder, this unknown intruder, frankly, would have been surprised by the multiple security measures. There's buzzing at the driveway where it meets the road, Northridge Road, the road on which the house was located. All 4 of the doors on the first floor beeped. It was a repetitive beep, 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 or 4 beeps maybe, if someone opened them. There's no signs of forced entry. That's the evidence that's presented. And it's dark. It's difficult to see in the house. There's no light there's no natural light at 6 in the morning in the middle of November, was the testimony. And Jeremy's sleeping when he's shot. So he's not disturbed by any beeps or buzzes. He's not disturbed by anybody trying to force their way in, which, by the way, the first responders couldn't even do. They tried to force their way into the house through that front door, which was locked with a deadbolt and a more general lock. And the police couldn't even get in. Interestingly and importantly, Ms. Simko never tells police or investigators that she was awakened by buzzes or beeps or anything like that. Jeremy clearly had not been disturbed by the buzzes or beeps of a door or someone trying to force their way in. And the killer was able to get the gun within, according to Dr. Mattis, the coroner, in a half inch, or an inch and a half to 2 inches of Jeremy's head before shooting him dead. Nothing stolen, it appears. Julene did say that there had been money in the china cabinet that wasn't there, but there was the evidence is that there was no indication that there was an envelope containing money. If any money would have been stolen, it's the money off the second floor from the office and the desk. Because remember, Julene says in an interview, I didn't go directly downstairs upon hearing what I believed were shots. I stayed upstairs a few minutes. So what was this person doing between the time that Julene's sitting on the second floor or third floor after having shot Jeremy? He didn't go look for anything to steal, or she didn't look for anything to steal, because that intruder, if there was one, was still on the second floor when Julene came down. It makes sense that an intruder who's in there would have gone to the desk to rummage through it. Didn't rummage through it, didn't rummage through the purse that was in the kitchen on the next to the overturned chair and where the gun was supposedly ditched. And interestingly, there's no unknown DNA, no foreign DNA located on the china cabinet where Julene's DNA was located, on the holster, which was grabbed, or on the inside doorknob of the kitchen door. But DNA was located.
Counsel, I'm going to interrupt you if you don't care. Just
Sure.
a couple things. The German Shepherds, am I correct that they were actually put into a fenced-in area during the night, or were they out roaming too?
They were not roaming.
Okay,
They were
they were put away. I think he placed them in. Yes, and then I'm sorry.
They were kind of big houses, actually. If you look at the photographs, I think it kind of shows that they were pretty good-sized dog houses.
Mm-hmm. Okay. And the other question I have is something, I only want information that's on the record. Okay.
Sure.
You're saying that, basically in the state's mind, this is pretty much an open and closed case, but because of all the ballistics, the DNA, all these things, but yet it took 5 years to indict her. Is there anything on the record as to why that delay? I'm on the record only.
No.
No. Okay.
Not that I'm aware of. I don't want to say that I wouldn't describe it as an open and closed case, but based on what's presented at trial, the intruder theory just doesn't work out. And look at the lies that Julene told. She's sleeping on the third floor at the start. By the way, there were 5 interviews. There was one at the house, there was one at the hospital, 2 at her mother's house, and then a 5th 4 years later with investigators from the prosecutor's office. She couldn't sleep and it was hot, she initially told police. Then Jeremy was moving around and had pushed her out of the bed, she told Sergeant Davis at her mother's house. Then there comes in this thing about Jeremy taking sleeping pills. 4 years later, she also tells investigators from the prosecutor's office that it wasn't uncommon for Jeremy to take sleeping pills. She had never said that. And oh, by the way, she adds, I took a half pill, sleeping pill too. All this just developing here. And the other thing though is there's no sleeping pills in the toxicology report from the autopsy. There's
there was Benadryl, right?
Benadryl.
Which is the ingredient that's put, did anybody talk about that's the ingredient that's put in Tylenol PM and Advil PM to make you sleep?
That was not discussed, Judge. I don't believe. And I don't know that Tylenol versus sleeping pills in a general sense, I think is different.
Well, Tylenol PM
Sure.
is not different. Or perhaps is not different.
I disagree in the sense that Tylenol's taken for pain. Tylenol's taken for pain. Sleeping pills are not necessarily taken for pain.
Okay.
Julene also says, I moved a handgun from Jeremy's nightstand to my nightstand because his nightstand was messy, yet left out a sex toy in the sink for multiple days by her own admission. She also had told a witness, Mr. Hopp, that she was going to see the the coroner, Dr. Mattis. Dr. Mattis testified that never happened. So, and I already mentioned the money in the china cabinet. When you add all these things up, the fact that Ms. Simko didn't divulge any persons of interest, suspects, anybody that police should talk to, that she said Jeremy didn't have enemies or issues with customers or employees, that nobody was having an affair, that the state ran down these far-fetched leads that law enforcement did, like a drug deal gone bad, that this James Brandow. The thing to remember, and listen to the interviews that Sergeant Davis does, the first three. He's never accusatory of Julene. I mean, he's really trying to figure out who did this, and it seems not believing that Julene would have done this. It's not until the fourth interview where the evidence doesn't line up with what Julene's telling them that he does. The couple of things I'd mention in regard to the manifest weight. The sergeant who came into the house did pick up the revolver, but remember, Julene called 911 within 33 seconds, had said that there's an intruder in the house. And she either says, I'm not sure if he's still here, or if he or she is still there, if the intruder's still there, or whether she actually says he's still in the house. He may be. So Sergeant Reinheimer had a choice to make, I guess. He could have left the gun on the ground, but practically he had no choice to make, any more than I have a choice to go to work in the morning. I do have a choice, yes, but I'm going to get fired if I just repeatedly don't show up. He had a choice to make. He could have left a loaded handgun on the ground for evidence purposes. That doesn't make sense. That's not a practical, pragmatic response under the circumstances. With regard to his DNA possibly not being on the handle, that's not accurate. There was insufficient data for comparison, and that meant that there was a small amount of DNA discovered on the handle of the handgun, but it wasn't a large enough quantity for comparison purposes. So to say that Reinheimer's DNA was not on the gun is inaccurate. It may have been, we just don't know. Detectives already convicted Julene Simko. Listen to the first three interviews. Someone may have said that, but Sergeant Davis certainly didn't act that way in conducting these interviews. Listen to his interviews with her. Regarding the blowback, investigators discussed the matter, unfortunately, it seems, with Julene Simko in that final interview with her. They probably should have discussed it with Dr. Mattis first and got their answers right there from him instead. Going to the second assignment of error, motive's not an element. The trial court was obligated to consider the possibility someone else shot Jeremy. Then, based on the state's evidence, the trial court found it implausible. Look, Julene Simko in her defense didn't sit back passively in this case, okay? But 33 seconds into the 911 call, she's saying someone shot her husband, and she never deviated from that. Someone else shot her husband. That's what she said, never deviating from it. She basically sort of presented an alibi defense. She was on the third floor. She wasn't at the spot where the murder was committed, where the killing occurred. The defense tried to sow doubt about the investigation. They tried to undermine facts pointing at her as the killer. Look at the closing arguments, the possible intruder, no definitive murder weapon, the talk about blowback, possible inadvertent security lapses.
Mr. Murphy, you are out of time. Go ahead and wind it up.
Thank you, Judge. That's a defense. Judge Carr, I'd point out you're correct on that first assignment of error. That's all you need to look at. Based on the evidence and the facts the state presented, the state established beyond a reasonable doubt that Julene Simko committed aggravated murder in this matter, that she killed Jeremy Simko, and we ask you to affirm the conviction. Thank you.
Thank you. Ms. Bremke, you have about 4 minutes.
Thank you. I will touch base on a few of the things the state said. I think they opened by saying that Ms. Simko relies on a lot of what ifs, but that's literally the entire case of the state and what the judge concluded with the mystery people. The state had also said that Ms. Simko failed to present any people of interest, which one is not true. And two, again, it's not relevant whether she can, it's not her burden. It is not her burden to prove that somebody else did this. And I think that everybody's looking at this as other people didn't do it, so Ms. Simko must have, and that's not the burden. We know that's not the burden. Ms. Simko did present alternatives, Mr. Brandau. The investigation was so poor that they had actually gotten in the tip, and this is in the record, they had gotten a tip about Mr. Brandau immediately after the murder and didn't investigate it until, I believe, right after Ms. Simko brings it up again in her final interview with the detectives. It was in like 2013. So about 5 years later, they investigate, and by that time he had died. Again, a poor investigation. And again, the state has said, well, they weren't accusatory of Ms. Simko in these interviews. What we know and what I've cited in my brief is that immediately after this murder, there's a recording which was accidentally left on where they say, I believe that Ms. Simko did this murder. So immediately there was a shield as to anyone else who may have done this. Again, I'm still not hearing anything about the facts that implicate Ms. Simko, but the fact that they're, that nobody else could have done this, and that's not the standard. As far as the DNA, the state had mentioned the DNA and that there was a amount of DNA that it was too small to determine. It could have been the assassin or intruder's DNA as well, number one. Number two, this detective put it in the small of his back against his skin, handled it without gloves, and there still was no DNA. It's certainly not a case where it was touch DNA. This was in the small of his back for a long period of time, and that's what the evidence, that's what the record suggests. There also is talk about the fact, I think the state said that Ms. Simko set up this scene, but there's testimony in the record that there would be no time from the time of that the coroner determined the death to the time that the law enforcement and first responders showed up for Ms. Simko to shoot Jeremy, send off a warning symbol sign, go downstairs, set up a murder scene, go back upstairs, make a 911 call. And I really encourage you to look at this 911 call. It's Exhibit 13, and there's just no way that it could have been faked. It's very genuine. It's so frantic. The very first interview, they call it an interview, but it was when they arrived at the home, and Miss Simko, she's crying so hard, and this is what the record reveals too, that she's inaudible. She's crying so hard and so frantic that she cannot even be heard. The state talks about inconsistencies in the interviews, which are very minute. There's 5 interviews over the course of, again, many, many years. Judge Carr hit the nail on the head, saying if this was a slam dunk case, why are we here 11 years later? This is not a slam dunk case. The inconsistencies are not enough that it deters Ms. Simko's credibility. Again, we're talking about whether she took a half a sleeping pill or not, and 5 years later, whether she remembers that. That's not a credibility issue. And again, what wasn't presented by the state is that Ms. Simko was also treated at the hospital because she was so frantic, and she was treated herself and given pills to calm her down. So these first 4 interviews are immediately after, when she's in shock, and she's also being treated herself for these, experiencing the loss of her husband, who she testified she loved very dearly, and they had a great relationship. So I will leave you with that. I know it's a lot here, but again, I want to emphasize that on the first and second assignment of error, although the judge has said a certain thing, this verdict, it's a 33-page verdict, the 9th volume of the transcripts, And the case that the state cites, this Vimpany, paragraph 11, it specifically talks when the record's silent. This record is not silent. The judge shifted the burden to Ms. Simko, which she didn't have. And then, of course, the evidentiary issues that we just discussed in the sufficiency and manifest weight and the ineffective assistance of counsel. I would present to you that there's no other option other than to reverse this conviction. And I ask that you do that. Thank you.
All right. Thank you both for your arguments in this matter. We will take the case under advisement, issue a written decision in due course. It'll be mailed to both sides as well as posted on our website and on the website of the Ohio Supreme Court. Everybody have a good day.
Stay healthy.